So good afternoon. First, I would like to thank the kind invitation of the Center for Sea and Society to participate in today's talk. For me, it's an honor to be here. And I will be discussing the potential compatibility and conflicts that may arise when offshore wind power overlap with marine protected areas that I will refer in this presentation as MPAs, and what are the circumstances when offshore wind power can be recognized as other effective conservation measures, also called OECMs. So this is an ongoing project that I am conducting with my colleague Niels Krabbe here at the department. So Baltic states have these ambitious plans to increase offshore wind capacity on an already crowded marine space to meet climate change mitigation targets. At the same time, the region has committed itself to protect until 2030 30% of the marine environment through MPAs, but also through OECMs. Achieving these goals will increase the spatial demands at sea, potentially leading to overlaps between marine protected areas and offshore wind power. If the conservation objectives of a particular MPA conflicts with offshore wind development, authorities could be forced, for instance, to prioritize between climate or biodiversity. But in many cases, offshore wind power may indeed function as an effective biodiversity conservation tool. This overlap makes it relevant to consider to what extent the legal framework supports or hinders the coexistence between MPAs and offshore wind power, and up to what extent can we recognize offshore wind power as OECMs. From a policy perspective, promoting coexistence has become a priority. Why? To minimize potential conflicting interest in the use of the marine space. But even where there are processes in place to promote coexistence, many states will find that marine spaces are too constrained to fully deliver on both objectives. So, before I begin with the legal analysis of coexistence, I would like to clarify what I mean in this presentation by an MPA and an OECM. MPA is by far a uniform concept. In general, we can say that MPAs are geographically limited areas where there are stricter environmental standards than the surrounding areas. Within protected areas, the scope and conservation goals also differ depending on the legal basis for the establishment and the authority that implements them. In this sense, MPAs may be subject to national, regional, or international law. Certain types of MPAs regulate only one activity. It could be only shipping, fishing, or mining. There are other MPAs that are cross-sectoral. That means that all human activities within this area are addressed and managed to protect marine biodiversity. MPAs are is not the same as non-human activities at all. It depends on the conservation measure. OECMs, on the other hand, is a broader concept than MPA, where the primary objective may not necessarily be the protection of biodiversity, but the protection occurs maybe as a secondary benefit or even as an unintended positive consequence. So when we're talking about conflicts, the conflicts that may arise may be between the deployment of offshore wind power and the environment, or the deployment of offshore wind power and other uses. In these conflicts, they are always spatial but also temporal components. For example, a spatial conflict between the user and the environment may be where a project overlaps with a marine protected areas that admits no human activity in it. A temporal conflict may ensue in the construction phase where marine species may be disturbed due to underwater noise. We can make a similar comparison of conflicts between users. For example, large-scale offshore wind structures may compete in space with shipping or fisheries activities. On a temporal dimension, fishermen may lose access to their fisheries grounds during maintenance works. So in this sense, multi-use ocean spaces have been developed as an alternative to minimize these conflicts. And from a practical point of view, maritime spatial planning has been identified as an essential tool to manage both of these type of conflicts, user-environment and user-user. So the objective is leading to coexistence. That is the policy, coexistence of multiple uses at sea. So a first point I would like to stress is that neither international law nor EU law prohibits coexistence of offshore wind power with MPAs. And there is a strong possibility that in the future, offshore wind power parks may be characterized as OECMs. This is because protected areas, as I mentioned before, are not synonymous with a total prohibition of human activities. Some could be, but not all. So coexistence from a legal perspective requires a balance of interests at stake. Those interests may arise between two states. This means that the rights of a coastal state, such as the exploitation of offshore wind power, enters into conflicts with the rights of other states, such as the right to lay cables in the same space. But interests could also be balanced between the users subject to the jurisdiction of only one state. In this case, it's easier for the coastal state to prioritize certain uses and displace others. So coexistence of MPAs and offshore wind power, I will say, is possible as long as the offshore wind is not contradictory with the conservation measure of MPAs. And that is a matter of science to give an answer to. The effects of offshore wind power on the marine environment can be subject to many categorizations. We have decided to include these preventive impacts and physical impacts. Preventive impacts are the result of the restrictions associated with the construction of offshore wind farms. Those basically refer to maritime safety requirements that often relates to rules of safe distances to avoid collisions. So this effectively will block two of the most important environmental pressure in the Baltic Sea context, because you force shipping and you force fishing outside these areas. And they take other routes, and the impacts of maritime traffic, including, for example, emissions or noise, are prevented, at least locally in these areas. And offshore wind installation has direct implications for fisheries. Fisheries are generally displaced for these developments. I would like to emphasize that even in states where they have been very active in promoting co-location of fisheries and offshore wind power, the success has been very low. So in most cases, offshore wind farms achieve the same effects as closed areas, promoting the conservation of fish and benthic fauna, which otherwise will be negatively affected, for instance, by trawlers. Scientific evidence also indicate that the wind power structures and the installation may function as artificial reefs. This means that the offshore structures allow for the colonization of marine species that use these structures as nursery areas. However, some studies indicate that the density of pelagic species remains largely unaffected by the installation of these parks. Others suggest that fisheries restriction in the long run will have a positive spillover effect into neighboring areas. But some studies also point out adverse environmental effects of offshore wind power. From a temporal perspective, the construction and the commissioning of offshore structures can cause underwater noise, dredging vibration, pile driving. During the wind farm operation, they find also underwater noise, electromagnetic fields, and changing in light conditions are some of the reported effects. Additionally, there is the possibility that non-native species may be introduced in these areas. So, as I previously mentioned, law does not prohibit coexistence of offshore wind power and MPAs. So depending on the level of protection, large-scale offshore wind power could be compatible with the conservation objective of a protected area. Coexistence from a legal perspective is not included in the United Nations Convention of the Law of the Sea, UNCLOS, yet this is not an extraneous phenomenon in the Law of the Sea. As marine uses and protection measures multiply, so does the competition for space. Since offshore wind power in the Baltic will mainly occur in the exclusive economic zone, not entirely, but mainly, this maritime zone is particularly important for developing multi-use ocean spaces. From an international law perspective, competition of space implies legally a balance of interest that have a legal expression in what we call due regard obligations. In the exclusive economic zone, coastal states have sovereign rights to exploit energy from winds that of course include the capacity, for instance, to prescribing procedures for granting licenses that could include biodiversity objectives, assessment of environmental impacts, requirements of how the structures must be designed to favor, for instance, the reef effect, etc. So, in principle, coastal states have ample discretion to select areas for developing wind power in their exclusive economic zone. Those areas may well overlap with MPAs. Yet, this does not imply the de facto priority over the rights of the coastal state to use a particularly marine space, because sovereign rights are not absolute. In the planning of MPAs and offshore wind power, then enters again the obligations of due regard. Due regard is actually a recognition that the coastal state's sovereign rights and functional jurisdiction coexist with the rights of other states. In other words, there is a de facto coexistence. But it is important to mention that the purpose of due regard is not to prioritize one state's rights over the others, but rather you need to balance and take into consideration all parties involved through obligations of consultation and negotiation. In fact, for instance, we argue in this paper that co-location of MPAs and offshore wind farms could offer a solution for minimizing spatial conflicts and avoiding restriction on the rights of other states, because you will not be using two spaces but only one. So coastal states have the jurisdiction to pursue in the same area both energy development and conservation goals. A potential limitation, of course, is that if you are going to pursue both, you have to comply with your obligations to protect the marine environment. Coastal states, again, do not only balance interests between different states, they also do it for the users of the same jurisdiction. In practice, this has been done through maritime spatial planning that has gained popularity to deal with this type of conflicts. At present, more than 100 countries have already implemented MSP processes and have passed relevant legislation. The European Union did so in 2014 with the adoption of a directive on maritime spatial framework. Article 5 of this directive explicitly promotes coexistence in the implementation of this planning. So, while the law of the sea convention provides a clear legal basis for offshore wind, it does not include a reference to MPAs. But the lack of a specific rule does not imply that this measure lacks legal basis from an international law perspective. The general obligation and jurisdiction of coastal states to protect the marine environment is generally considered extensive and flexible in scope. But the problem with establishing MPAs, specifically when you want, for instance, to restrict fisheries or to restrict shipping, is that you will need, for instance, the approval of certain organizations or the cooperation of other states. This is because the measures that impact legitimate uses of the sea, in particularly navigational freedoms, and the undertaking related to regional fisheries management, the ability to the coastal state to impose these environmental measures is much more constrained in the exclusive economic zone. For instance, imposing additional environmental requirements on shipping in specified areas of the EEZ requires acceptance of the IMO, as coastal states can only give effect to generally accepted international rules and standards. In the European Union, For fisheries, we have the EU Common Fisheries Policy that raises particular challenges for MPAs and fisheries because it requires effectively the support of the European Commission and the Council for MPA measures that restrict fisheries. So, while both the law of the sea and EU law aims to promote opportunities for coexistence among competing interests, the degree of autonomy granted to the coastal state in designated maritime spaces differs considerably depending on the purpose. For offshore wind installations, coastal states have much more discretion in the planning of this development. In contrast, MPAs that impacts shipping or fisheries requires coastal states to undertake more burdensome processes and seek active consent from other states. This difference is noteworthy as it raises the question, up to what extent can we use offshore wind farms as a means to achieve certain conservation outcomes in cases where the regulative and procedural difficulties hinder the actual establishment of MPAs? So, from a policy perspective, the states have committed to protect 30% of the marine environment by 2030 through MPAs, but this goal can also be achieved partially with OECMs. Out of this 30%, 10% must have strict management measures. This basically means very limited or no human activity at all. So in this 10%, no collocation with offshore wind power is possible. However, most MPAs will allow a degree of coexistence with other marine uses. To assess the compatibility of a marine use that overlaps with an MPAs, it is fundamental to assess the impacts of the proposed activities. In particular, from a legal perspective, states should act with due diligence and in accordance with the precautionary approach to prevent damage. Arguably, the coexistence also allows and tolerates a certain level of harm. So coexistence could, in fact, happen even if a certain harm occurs. Most MPAs regulations allows coexistence after conducting environmental impact assessment. The requirement for conducting environmental impact assessments is stipulated in numerous binding and non-binding instruments. To mention a few, for example, the Convention on Environmental Impact Assessment in a Transboundary Context, known as the ESPO Convention, UNCLOS, and the Convention on Biological Diversity, to mention a few. In the Baltic Sea area, the HELCOM Commission has not adopted any environmental impact assessment guidelines for offshore wind structures and installations. However, they have a recommendation for safeguarding important bird habitats and migration routes in the Baltic from the negative effects of wind and wave energy production at sea. And what they encourage their member states is to conduct strategic environmental assessments and environmental impact assessments prior to the establishment of offshore structures at sea. Additionally, the recommendation includes a series of suggestions for the member states of the Baltic of HELCOM, including mapping bird migration routes, staging areas, the application of the precautionary and ecosystem-based approach, the exchange of information, joint assessment of cumulative impacts, monitoring, and a very interesting suggestion as well, planning the marine space in the Baltic from a Baltic-wide context. So we have to look beyond national boundaries when we plan the marine space. A similar approach is found in the Agreement on the Conservation of Small Cetaceans in the Baltics, the ASCOBAN treaties, where the meetings of the party to this treaty recommends states again to conduct strategic environmental impact assessments and environmental assessments to take into account cumulative effects. In the work that we are conducting, we're looking into MPAs established under the HELCOM Commission in the Exclusive Economic Zone, that in these areas they overlap, all of them, with the protected areas established under EU legislation. There is the Birds and Habitats Directive, also known as Natura 2000. From the wording of European legislation, there is room also for coexistence between protected areas and other uses, plans or projects such as offshore wind power. If the project is expected to have significant impact on the environment or the habitat, an assessment is necessary before the authorization is granted. However, a plan, a project, a use may still be approved in the face of a negative assessment, provided that there is an overriding public interest. So even if the MPA or the habitat is affected, if you can demonstrate a public overriding interest, you can approve the plan. What constitutes overriding interest has been subject to debate, but there is a Council regulation of 2022 that provides a framework to accelerate the deployment of renewable energy that introduced a rebuttable presumption that renewable energy projects are of overriding public interests for the purposes of relevant environmental legislation at EU level. Additionally, the Renewable Energy Directive, RED III, requires member states to map suitable areas for the development of offshore wind power, as long that you ensure that these locations will not lead to significant environmental impacts. That does not mean that it requires no environmental impacts. What is required is not to have significant impacts. RED III also aims to streamline permitting processes, and what we can see with these legislative developments is a clear prioritization, at least at EU level, to energy transition in the European Union. Then OECMs have three approaches to biodiversity conservation: primary conservation, secondary, and ancillary. Under primary conservation, OECMs are technically MPAs, but however, the managing authority has chosen not to designate them as a protected area formally. But in relation to the development of offshore wind power, secondary and ancillary conservation measures are far more relevant. Secondary conservation focuses on active biodiversity management by the authority. For instance, that they limit shipping or fishing in the wind park to minimize environmental impacts. So in this context, the main goal of the OECM is the generation of electricity. It's not the protection of biodiversity, but the management authority also proactively incorporates secondary conservation strategies. So given that large-scale offshore wind power is a relatively new marine use, there are numerous possibilities for establishing secondary conservation measures, including licensing procedures that include monitoring obligations in relation to the impacts on the marine environment, infrastructure design, and the restriction of other activities such as trawling. It is important also to notice that OECM does not imply a complete absence of negative impacts, but what is the level of harm has yet to be established. Probably it has to be analyzed by a case-by-case approach. At the moment, offshore wind power has ancillary or incidental conservation effects. This means a de facto exclusion of certain activities. For instance, shipping and fisheries are displaced, but basically to safeguard the safety of the installations, to prevent collisions. Furthermore, these physical structures associated with offshore wind farms, such as the foundation installations, contribute positively to biodiversity by creating the artificial reef effect. The reef effect at the moment is classified as an ancillary benefit, but it may well qualify as a secondary conservation measure if the design of these structures from the outset and from the requirements of the law requires biodiversity conservation. So also a particular characteristics of OECMs is that they are identified or recognized. They are not established. This is, and why is this? Because you need to see how these other activities generate positive impacts in biodiversity. So both the law of the sea and EU law promote opportunities for coexistence among competing interests. But the degree of autonomy of states to either implement an offshore wind power or an MPA varies. For offshore wind installations, coastal states again have ample discretions to do it, while MPAs may have more regulatory constraints. So this difference is noteworthy as it raises the question of whether the establishment of offshore wind farms could function as a means to achieve conservation outcomes in cases where there are difficulties in the establishment of MPAs. So I think that this, sorry, yes. So also I would like to mention that OECMs are far more suitable for fostering coexistence between offshore wind farms and environmental protection. This is due to the unique characteristics of OECMs. What are those? That the primary objective of OECMs are not necessarily the protection of biological diversity, but the protection can be the result of secondary measures or even an unintended consequence. As a final reflection, I would like to leave you with this reflection that multi-ocean spaces offer a potential is a potential to reduce spatial conflicts at sea by fostering coexistence. And offshore wind power, if designed with biodiversity in mind, can be both complementary and compatible to MPAs. The level of compatibility has to be assessed a case-by-case approach, considering, of course, each of the specific management requirements of the MPA. While MPAs often intentionally limit the human interference, the construction of offshore wind power have ancillary conservation results. OECMs can complement the achievement of the 30 by 30 target and is a flexible approach to promote coexistence. However, I think that it is still very premature to designate offshore wind power parks as OECMs because this area-based management is result-oriented. Specifically, the measures must result in a sustained long-term outcome for the in-situ conservation of biodiversity. The long-term effects of deploying large-scale offshore wind power and the effects on biodiversity has to be assessed several years after the parks are in operation. Thank you very much. I'm looking forward for your questions.